Hi, this is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2021 Virtual Supreme Court competition. This year, we're arguing the case of New York State Rifle and Pistol Club versus Bruin. We are now in the semifinal rounds, match number 12. From Texas, we have Campbell Collins and Gabriella Lovins. And from Eden Prairie High School in Minnesota, we have Avik Garg and Zachary Kirkby. Petitioners, whenever you're ready, you may begin.
May it please the court. My name is Gabriella Lovins, and along with my co-counsel, Campbell Collins, I represent the petitioners, New York State Rifle and Pistol Association, Robert Nash, and Brendan Koch. Petitioners have been denied applications for concealed carry licenses under a New York statute titled the Sullivan Act. This is unconstitutional and violates petitioners' Second Amendment rights.
Would the court like a brief statement of the facts?
Yes, please.
Both Robert Nash and Brendan Koch applied for a concealed carry license in New York titled an unrestricted license. But both of their applications were denied because of the proper cause requirement in the New York statute, which explicitly requires that applications for a statute come with a distinguishable need for self-defense beyond that of an ordinary citizen. It was determined that neither a desire to carry a handgun because of robberies in one's neighborhood, nor a generalized desire for self-defense met that standard. So both of their applications were denied.
The question presented today is whether the government may prohibit a law-abiding citizen from carrying handguns in public for self-defense. The government cannot prohibit this for three reasons. First, it violates the keep and bear arms clause of the Second Amendment. Second, the law fails the strict scrutiny test. And third, all other justifications for this law fail.
First, this type of...
If I can jump in. So let's start with your first argument. We have these verbs to keep and to bear. Did Heller resolve what bear means?
No, Your Honor. Heller did give us some direction as to what bear means, but because they were dealing specifically with a law that dealt only with the keep portion of the Second Amendment, the meaning of bear arms is still a little bit up in the air.
But what direction did Heller give us for bear?
We do know that the court in Heller decided that the word bear means to carry, and specifically that includes carrying outside the home, which is exactly what the petitioners in this case desire a license for.
But does knowing what bear mean get us to shall issue? In other words, maybe you're right? Maybe that the Second Amendment protects the right to bear outside the home. I think maybe the other side might even agree with you on that. But how do you get from that simple fact to shall issue?
Well, Your Honor, the way those two are connected is by looking at the sum total of the laws in New York, for example. So because New York bans the bearing arms openly, and also severely restricts the ability of citizens to carry arms in a concealed manner, the laws in New York amount to a total ban on the ability of ordinary citizens to carry handguns for their self-defense. And the reason that may issue clause or the proper cause requirement in the law is impermissible under the Second Amendment is because it turns a right explicitly guaranteed to the people, to all citizens, into a privilege that must be granted by a licensing officer.
Well, let me ask you this, Counselor, if I may interject. Haven't there been a number of good cause laws that have been rather long-standing, dating back to, I believe, the 19th century? Why those hurt you clearly? Can you speak to those for a second?
Yes, Your Honor. So when looking at whether a law is longstanding and therefore constitutional, we have to look at a couple things. First, was it in place when the Constitution was ratified? Second, was it in place when the Second Amendment was ratified? And third, was it in place when the 14th Amendment was ratified? Because before the ratification of the 14th Amendment, no Second Amendment laws actually applied to the states. So I believe actually all of the laws that have been referenced by respondents in their brief came before the ratification of the 14th Amendment. And they also came before the first open carry ban in the United States, which was in Texas in 1871. So when there were bans on concealed carry, there were not bans on open carry, which gave citizens one avenue of exercising their Second Amendment right to carry for self-defense.
So let me pause right there. I think this is an important part of this case. Does New York permit any open carry?
Well, Your Honor, that is a little up in the air because New York may permit, although it's a little bit unclear from the laws, they may permit the open carry of rifles, and they do permit the open carry of historical weapons or replicas.
Let's just assume, because I agree, if the facts are somewhat in dispute, that open carry of a handgun is not permissible. Would you accept as a remedy for your clients the right to open carry a pistol? Would your clients be okay with that?
Yes, Your Honor. Leaving open the avenue of open carry in the state of New York, even if the pathway of concealed carry may be restricted, would satisfy the way that courts have analyzed this type of requirement in the past by looking at all the avenues that citizens can
So
carry.
then how do you square the open carry with the Statute of Northampton?
Well, Your Honor, the Statute of Northampton is actually a very interesting piece of legislature for a couple reasons. First, its true meaning is somewhat up in the air. But what we look at, whenever we look at the times it's been applied, even the quote that respondents themselves cite in their brief, there's an important phrase of the terror of the people, as well as dangerous and unusual. So the Statute of Northampton seems to be referring to any time you carry weapons in public for the terror of the people, so to terrorize them, or when you carry them offensively, or when you're carrying.
Do we have any cases that interpret the statute?
Yes, Your Honor. In DC v. Heller, the Supreme Court looked to historical interpretations of the statute and determined, based on the analysis in Blackstone's commentaries, which would be contemporary analysis roughly at the time of the founding and the framing, that the prohibition had been interpreted in the past and should continue to be interpreted as a prohibition against bearing arms offensively, not defensively.
Well, let's move on from history and pivot to scrutiny. How does this fail strict scrutiny? Can you give us an explanation?
Yes, Your Honor. So there's two prongs to strict scrutiny, whether there is a compelling state interest and whether it's achieved in the most narrow and necessary means possible. This law fails both prongs. First, the burden is on the state, the government, to prove that their law actually achieves a compelling state interest. This compelling interest in today's case would be reducing gun violence. But there's many studies that show, first of all, there is a particular study which came out January 12th of this very year, showing no effects of this law on the actual violence in the city. Second, this law, when you look at whether or not those who apply for concealed carry licenses are actually committing violence, we see that less than 1% of people who have legal concealed carry licenses commit gun violence. So then we come to the second prong, which is, of course, is it done in the most necessary and narrow means possible? It fails that prong too. To truly be in the most narrow means possible, it wouldn't take guns out of the hands of the everyday people with the everyday need for self-defense who want to protect.
Right, but doesn't the state allow guns if you show a sufficient need? I mean, there is an avenue by which your client's good. They just didn't meet the threshold.
Yes, Your Honor, that comes down to the proper cause requirement in the statute. But that requirement is unconstitutional because it requires citizens to prove that they deserve to exercise their fundamental constitutional right.
It strips you of your right, and then a bureaucrat gets to decide if you're good enough or if you have enough reason to be clothed in the protections of the Second Amendment.
But don't we have many cases where government bureaucrats, and maybe that's pejorative, depending who you are, but where government bureaucrats can make decisions based on discretion? I mean, we have an entire administrative state that makes decisions on all sorts of things. I mean, what's so bad about bureaucrats? You ever go to the DMV? I mean, my goodness, right? And what's so bad about bureaucrats?
Well, Your Honor, in this particular case, the problem is that the right to bear arms is enshrined within the Second Amendment. It's in the Bill of Rights. And so it's not something that the state can just take away, and it's not something that the state has discretion to just willingly remove. To add
Okay,
on
but to play devil's advocate there, we have plenty of restrictions on First Amendment rights, right? I can't scream fire in a crowded theater. How is this any different?
Well, Your Honor, those restrictions deal with things such as the time, manner, and place that you can exercise your First Amendment rights. But the law in this case is fundamentally different because it deals with people. It allows the state of New York to determine who can exercise their Second Amendment rights, not how they exercise those rights.
So you have 30 seconds left, Counsel, if you want to wrap up.
Yes, Your Honor. For the following reasons, and because this law fails strict scrutiny and infringes upon our client's Second Amendment rights, it's unconstitutional.
We pray that this court will reverse the ruling of the lower court, render judgment declaring the statute unconstitutional, and enjoin enforcement of the statute against the petitioner.
Okay, excellent. Thank you so much, petitioners. I'll stop the timer. If response can please come back on camera. You'll have 15 minutes for your argument, and you can begin whenever you are ready. I think you're on mute, Counselor. That's okay.
Just to check, can you hear me clearly now?
Loud and clear, Counselor, whenever you're ready.
All right, perfect. Okay. Thank you, Mr. Chief Justice, and may it please the court. New York State's proper cause requirement for the concealed carry permit of handguns falls well within the text, history, and tradition of the Second Amendment. We agree with the petitioners that the Second Amendment protects an individual right to bear arms. However, the Second Circuit Court and Heller both state that no right is unlimited. In this case, we can look to nearly 700 years of text history, starting with the Statute of Northampton, moving on to gun surety laws, then moving on to most states in the 20th century that all required gun owners to show proper cause and proper need for self-defense. In addition, concealable weapons fall under a category of weapons that face much more stringent regulation. I am happy to answer any questions the court may have.
Sure. Well, let's start off where the other side left off. You say 700 years. How are you? I'm guessing you're talking about the Statute of Northampton, I'm guessing.
Yes.
How do you read the Statute of Northampton differently than your friends on the other side?
So we look to the Statute of Northampton where first we define that concealable weapons, as the framers had said, are a tool that are naturally going to be used for crime. A concealable weapon is going to intrinsically be a dangerous weapon and inspire fear and terror. In addition to that, the fear and terror clause is not something universally adopted in gun laws of the time. In our brief, we discuss how there's an evolution of gun laws using New Hampshire as an example, which doesn't.
But do you disagree? I just want to focus on the language, right? The Statute of Northampton speaks of terror and these other sorts of words. And I think your friends on the other side made this. How do you respond to those arguments that they're reading the Statute of Northampton?
Yeah, so I think we first look to sort of the plain text of the 1328 statute. And in the plain text, it talks about two different things. It talks about sort of this fear and sort of offensive nature of the guns, but it also has this clause that says no part elsewhere. And we think that sort of makes it apply to sort of every other sort of weapon. And I think we also cite in our brief this case of Schoon versus Peto, which makes the argument that this sort of applied and was actually used to sort of criminalize behavior that, while we wouldn't think of it as like causing special fear or terror, was generally applicable to any gun owner who carried their gun outside the home.
All right, so let's move on from the 1300s to the 1600s. Let's look at the English Bill of Rights. I know your friends on the other side references. How do you account for the English Bill of Rights and this right to bear arms?
Again, I don't think we really think of the English Bill of Rights as sort of being the de facto sort of statute here. I think we agree with them that we can sort of move past the English Bill of Rights and look to the American Bill of Rights as being more sort of expansionist in terms of the right.
So you think the American Bill of Rights is more narrow or more broad than the English Bill of Rights?
It's a more broad right, so more conduct is sort of restricted.
It's a broader restriction than the American Constitution.
The American Constitution, yeah, it's a broader restriction.
So actually, by declaring independence, the Americans gave up some of their liberties as Englishmen.
I think I might be like confusing double negatives here. No. So the Americans did not give up more of the rights. They got a broader sort of right. But we'd argue that right is still not that broad in terms of this sort of carry provision. And that is where we lie the most of our.
Okay, so your friend the other side explained that if with this proper cause, this good cause standard, you effectively have a privilege and not a right. How do you respond to that argument?
So we start with the idea that, once again, no right is entirely unlimited. Next, the proper cause requirement doesn't necessarily make it a privilege. It just requires people to clearly articulate that they need this dangerous tool for self-defense. And they have to just simply properly prove out that they have proper cause for it.
It's not a matter of how persuasive you make your case. You have to have a life situation that meets the standards of some, to use your phrase, some bureaucrat, right? I mean, that's not usually how we think of a constitutional right. Can you think of an analogy in other contexts where a constitutional right is subject to such discretion?
I mean, of course, Your Honor, it's not common, but we think that there are sort of different situations that face similar restraints, such as things like, for example, Fourth Amendment rights, where it is subject to a bureaucrat and it is subject to sort of a warrant requirement, where you do sort of get these similar provisions. Similarly, we think the First Amendment, when you sort of have different time, manner, place restrictions, sort of meet these similar requirements of.
Right, but with a time, place, manner restriction, it's not based on your viewpoint, so to speak, right? It's got to be a neutral restriction.
Again, I think, but the point of bureaucrats being sort of involved sort of applies similarly, right? So it's still a content neutral restriction, as you would put it.
So for example, let's say, council, I apply for a parade permit, and I want to parade for whatever my organization is. You say, you know what? You don't really need that parade permit. I don't think your organization is that important. Let's give it to someone else who really needs that parade permit. Would that work?
Of course not, Your Honor, but I think similarly in this case, if, for example, the court denied someone who had shown proper cause, shown sort of they have all these sort of that their neighborhood is super dangerous, then an appeals court would be perfectly justified in overturning a judge's decision, denying them a permit.
Well, let's talk about the good cause standard and that appeals process. So I could have envisioned a scenario where someone doesn't have a specific need or specific enough threats to convince a bureaucrat that they should be given a license to carry. And in between the denial of the license to carry and the appeal, a violent act occurs to them and they are hurt, or worst case scenario, they're killed. I mean, can you see how this infringes on that right to self-defense that Americans inherited?
Of course, Your Honor. I guess I'd make 2 points. I think the first, like, if you're insinuating that there might be some sort of tort remedy that you could say, oh, I should have gotten sort of this sort of permit to carry, but I was sort of in danger and I was shot. I think that one problem with that would just be that if, for example, you needed for an open carry or a rifle in order to defend yourself, you could sort of make a similar argument. And our point is that while there might be circumstances in which case this sort of restriction would strip you of your rights, reasonable restrictions are still necessary.
Sure. Okay, so let's talk about the reasonableness of this restriction, because it's my understanding that at least one of the petitioners is able to carry his firearm to and from work. Am I correct in that understanding?
Yes, Your Honor. The petitioner Koch was able to carry to and from work.
Right. So if he's able to carry his firearm to and from work, why is it any different? Why is the state denying him the right to carry his firearm to and from a retail store?
Yes, Your Honor. I think the reason for that is that he hasn't shown sort of articulable need. I think in this case, sort of his work was a more dangerous path, and the court sort of recognized that by showing that it was a more articulate need.
Proceed with your argument, counsel.
Thank you, Your Honor. So addressing the petitioner's brief where they talk, pages 14 and 15, where they talk about how the right to keep and bear arms, since they are on the same line, they have to be weighed the same. We can look to the Fourth and Fifth Amendment to see why that simply is not true. Starting with the Fourth Amendment, the right to be secure in one's person, home, and effects are all listed on the exact same line, but there is huge differences in how that's actually applied. In order to search one's home, a full warrant is required, whereas a car can be searched on the presumption of marijuana.
Next, there's also like one.
Counselor, can I interrupt you? I would like to go into the part of your brief where you talk about that a ban on all carry of concealable weapons has a longstanding tradition, and that New York's law would be constitutional even if it did not permit anybody to carry a gun. So are you trying to say that not only is this limitation constitutional, but so is a ban on all right to carry?
No, Your Honor, there's a distinction between sort of open and concealable weapons. If New York banned concealable and open completely, then that would obviously be unconstitutional. As you know, there is a dispute in this case over whether open carry is sort of allowed by New York's laws, but we're saying if only concealable weapons such as handguns were not allowed, that would be something that would be perfectly constitutional.
Well, let me tweak Justice Wallace's question for a minute. Why would it be unconstitutional for New York to ban all open and concealed carry? Why?
Because that would sort of move us outside that sort of tradition in history, because that would sort of make it much more of an infringement on this right to carry.
So you think the tradition is as long as open carry is allowed, you can ban concealed carry?
Yes, I
Yes.
think our cases
So
sort
would
of.
you be willing to stipulate, and New York stipulates that you're gonna now allow everyone to open carry, you're just gonna ban concealed carry? You're gonna go for that?
Of course, if this court does make that decision.
No, we don't. Maybe we can settle it. We can have a settlement, right? What if we don't have to decide this case? What if New York says, here, you're the lawyer for New York, you say, yes, you can open carry, no, you cannot conceal carry. Case over. And I think I asked my friend on the other side, they'd be okay with that. So,
I'm fairly sure, I mean, I haven't asked the legislature that they would rather have the open carry not allowed. And that would sort of be their position. I think what we use that point to demonstrate is that even if it's not true that sort of any sort of complete ban would be completely allowed, it does sort of move the sort of presumption away from us, sort of even getting rid of this modest restriction on sort of a requirement.
okay, you may proceed, counsel.
Next, if we could, I'd just like to quickly move to the issue of scrutiny in this case. If this court does find that the history is unclear, an additional basis to sort of affirm the Second Circuit would be intermediate scrutiny. And we think you should use intermediate scrutiny because it best coheres with the history
I'm
of
sorry,
the.
so if we use strict scrutiny, do you lose or do you win under strict scrutiny? I want to.
We lose under strict scrutiny.
You can see that point. Okay, fair point. Okay, so then tell us why you think you would prevail under intermediate scrutiny.
Yes, so intermediate scrutiny has two prongs. First, that there's a substantial interest, and we think that there's obviously a substantial interest of public safety. And second, that there needs to be a reasonable fit. And we show on page 15 of our brief that there is sort of a difference between if you have only a shall issue regime, then most of the gun homicides happen by people who do not have a previous sort of felony history. And so those sort of people would still be allowed to carry a gun. And our argument is that sort of an articulable need sort of best strikes the balance between self-defense and public safety.
But how do you look at, like, I think 40 something states have some form of shall issue, and they're not like the Wild West, right? They managed to do okay. So we're not strict scrutiny, but intermediate scrutiny, it's good enough. Why couldn't a shall issue regime work in New York so long as there's adequate background checks and perhaps fire proficiency training?
2 points. First, sort of this adequate background check is just not sufficient, is sort of our main point, because of the fact that that is about sort of felony criminal history or maybe red flag laws. And those things just don't sort of cover the entire need. Second, we'd make the point that even if other states have sort of an effective system, New York is definitely able to sort of say that, like, we think a different system is best for our state, which has much bigger population density and sort of has different sort of characteristics to how the state runs.
Well, let's talk how I think I'm inclined to agree with you that perhaps you meet intermediate scrutiny. How did you arrive at that decision? Is there a precedent on point that definitively establishes that these sorts of regulations are analyzed under intermediate scrutiny?
Yes, Your Honor. I think the circuit courts have done a lot of sort of cases under the Second Amendment, and a lot of them have come to this sort of two-step test. And I could cite you different cases, such as.
Let me clarify myself. Is there anything from this court that definitively establishes that?
No, Your Honor. The court in Heller and McDonald both decided to sort of view history as dispositive, and we agree with that conception. But if history is unclear, I guess we'd make the point that when history is unclear, there is no presumption to either side. And so intermediate scrutiny is the best point. And if I could, I'd just like to quickly respond to sort of their point on page 18 to 19, where they say strict scrutiny should be preferred. And I think the problem with their argument is that it is about the core right. And that sort of begs the question. If it is a core right, if they show that the history is clear on their side, then the history is dispositive and they sort of win this case. But if the history is unclear, that is when you should use intermediate scrutiny, because it is the best sort of form of doctrinal test that coheres with the sort of history of the Second Amendment.
All right, well, so Counselor, let's just talk for a minute, right? How do you define the phrase sensitive places?
Sensitive places, well, at the moment, schools and hospitals, for example, are defined as sensitive places, as there are a large quantity of people who have no means to defend themselves. In the case of New York, with the sheer population density within New York City, it is reasonable to presume each street would be a sensitive location just due to the sheer quantity of people present.
So would the entire island of Manhattan be a sensitive place?
Maybe not the entire island, but sort of areas like Times Square, maybe busier streets.
Well,
I
pretty
don't know.
busy.
if
I
the
mean, your
draw-
friend Domingo, it's a pretty busy place. Never sleeps. I mean, can we declare the entire island of Manhattan a sensitive place?
I mean, I don't think it would be proper to declare the entire island, but maybe sort of a large chunk of
What
it.
if the petitioners didn't live in upstate New York? What if they lived in, Midtown Manhattan? Do they have no right to bear arms? There's crime there, homicides all the time.
I mean, I don't know if they'd have, I'm sure the legislature would still allow them to have a right. Maybe sort of there's no constitutional right. I see that we're sort of running up
Fine,
against.
that's fine. Okay, I appreciate it. I was pushing you into your limit. All right, that's very good. Thank you. Petitioner, you now have 5 minutes rebuttal time. Please come back on camera. Okay, whenever you're ready, begin.
And may it please the court. We'd like to address 3 different aspects of the unconstitutionality of this law. First, that while the appropriate standard of scrutiny is strict scrutiny, this law is unconstitutional under either strict or immediate scrutiny. Second, that the way this law deals with handguns and sensitive spaces is unconstitutional. And third, looking at the fundamental nature of the Second Amendment, this law is unconstitutional.
Now I'd like to talk about the level of scrutiny and address the arguments respondents made. So when we're deciding if a law should be analyzed under intermediate or strict scrutiny, there's 4 questions we have to answer. First, is it a fundamental right? The Second Amendment protects a fundamental God-given right. So yes, absolutely, it's a fundamental right. The history is frankly irrelevant.
Is it the right of open carry or concealed carry? What actually is a fundamental right in history? I think there's some discussion about this.
Well, yes, Your Honor. So there's, as we said in our original arguments, the first open carry law came in 1871. So I guess the important part about open versus concealed carry is that one of them is allowed for most common weapons. And I know there's dangerous and unusual exceptions, but we're talking about the common weapon and the handgun. So when we look at the first question, it is a fundamental right to carry in some form, common, and weapons chosen to be used by the people. Second question.
So what if they're right that the actual deeply rooted circle right is about open carry? Does that affect your argument at all?
Well, Your Honor, no, because the right to open carry, if it has shifted to be a right to concealed carry because states have started to ban open carry, it's not necessarily about the way that citizens are able to bear arms, just that they're able to exercise the right that's specifically in the text of the Second Amendment, the right to bear arms.
What's the core of the Second Amendment? Is it open carry, concealed carry?
It doesn't matter, Your Honor. It just matters that there is a way for citizens to carry firearms.
So you would define the core as carry, and then your friends on the other side define it as perhaps open carry, although I'm not exactly sure what the position is, right? And you say it doesn't matter which one. How do we as a court know which one to pick, your side or the other side?
Well, Your Honor, we have to look at the context that the New York law sits in. In New York, open carry is completely banned. So this law is unconstitutional because it severely limits the only way that citizens are able to bear handguns in New York.
All right, let's talk about public policy for a minute, right? How many dead bodies would it take for you to reverse your position?
Can you, are you asking us how many people need to die of gun violence for us to be willing to ban all guns?
In order to defend New York's position, like let's say we rule for you. Let's say in a couple of years, the homicide rate goes through the roof and we find that people with concealed carry permits are engaging in violent homicides. Would that change your position?
Well, Your Honor, that would affect the level of scrutiny in this case, because as of right now, New York bears the burden to prove that their law achieves the interest it sets out to, and they haven't done that.
So if they come back in 3 years and say, look, we've had this shall issue policy, all these dead bodies in the street piling up, would you change your position and support the may issue policy?
Well, if that was to happen, clearly there needs to be a law to protect citizens. That law does not need to be taking away more guns, because one of the best ways to stop unexpected violent attacks is to have a weapon with you so you can protect yourself.
The other side has statistics saying that's wrong. They're saying having a gun present can actually lead to more violence. Self-defense, sure, but lead to more violent crimes.
Well, Your Honor, because of the conflict in the studies and the conflict in the analysis, the case before the court today is materially different from a case in
But
which
there's a conflict. What should the presumption be? One of deference or one where we rule against the state? What should the presumption be in the face of conflict?
well, Your Honor, because here the burden is on the state to prove why they're depriving citizens of a constitutional right, they bear the burden, and it's a burden they haven't met.
Okay, you have about 30 seconds left. You can wrap up.
Yes, Your Honor. So as we've stated, this law fails both intermediate and strict scrutiny. It fails intermediate scrutiny because it is not substantially related to the interest because it takes gun rights away from everyday law-abiding citizens. We pray that this court will reverse the decision by the lower court and render a verdict declaring the New York statute unconstitutional.
Thank you. Right on time. All right. Other time, come back in camera. My goodness, that was good. That was, I think, one of the top rounds we've had so far. Top. I mean, we're almost done. We have only one more after you guys. That was one of the top we've seen. That was fantastic. And I think you were evenly matched. Not that you're competing against each other, but you went pound for pound, one to the left to the right, punch, punch, punch. You read each other's briefs. That was really obvious to me. And you paid attention to what the other side was saying. That was extremely impressive. I threw some very bad questions. The dead bodies one, you didn't even flinch. You didn't even like, oh my God, right? You didn't like roll your eyes or anything, but you just sort of took it. And I asked you some hard questions too about banning altogether and the entire island of Manhattan. You just sort of took it. That was really, really strong. The four of you, the lot of you could walk into law school tomorrow, win a championship. Just walk right in tomorrow and compete. It's really remarkable. You're arguing over the Statute of Northampton and what do they mean? It's 813 whatever and the English Bill of Rights. And then one question I was like, it doesn't matter. And that's the right answer. It doesn't matter sometimes which one you pick. That was super impressive. You also, I appreciate you're both in person. Some of our teams were remote. You handed off seamlessly from one to the next, and that was very effective. I thought you did a really good job at transitioning. I'll give some maybe criticism later, but I'll go back to Ashley and read just some of your thoughts.
No, I thought y'all did really great. It was actually a really fun round to watch, and just seeing each other go back and forth. And like Professor Brockman said, like anticipating each other's arguments and quoting each other's briefs really just showed that y'all were prepared and knew what was going on. Another thing I really wanted to compliment y'all on is that we haven't seen a lot is y'all are really respectful of the court's time. And I think that's something in the future too, that'll be a big deal is, you know, you didn't go over and you just made sure to be back, and you even gave the court their time back. Like you never went over. So I think that was really great.
Yeah.
And then another thing is y'all actually conceded points that you knew you were going to lose on instead of just trying to make essentially frivolous arguments that weren't going to last. It makes us respect your point more and, you know, kind of just see where you're going with that. So I think y'all did really great.
Yeah. The fact that you concede strict scrutiny is smart because all these teams before have tried to argue and they lost. I mean, there's no way you can spend this under strict scrutiny. So just leave that on the table. And I think that was a very strategic. I'm sure you discussed this in advance, right? This was like you didn't just make this up on the fly. And also for Gabriella and Campbell, the open conceal issue I think is very tricky. And I think you handled that well. You conceded one. They said, well, if we're allowed conceal, we're good, right? I mean, obviously you don't have a client, but you just sort of made that point. And I would have loved, you know, asking about what would New York State allow. You said, well, let me go call the governor, right? But, you know, you could, you actually like, you said, I don't know the answer because, you know, Blackman just made this thing up, but you handled it well. So this was good. Reed, I didn't want to cut you off, but Ashley made a very sharp point I wanted to elaborate on.
Yeah, no, this was high level law student. I dare say practicing attorney level advocacy. I've seen some attorneys in court not rise to the standard that you guys set today. This was very good. Your demeanor was excellent. Smiles go a long way, especially at the end of a long day. I didn't mean for that to rhyme, but I thought every knowledge of the law was fantastic. Tone, tempo, excellent. I think we might have a future Solicitor General in the Zoom call. This is excellent.
I agree. Yeah, I'm going to give you very small criticism because it almost doesn't even matter. But a couple times when I asked you like a blow up question, there was a little bit of a chuckle. It was very subtle, and when you watch video, you'll hear it. Like oh my god. But cut the chuckles, right? Just keep your face poker face, right? Poker face. Keep your poker face and don't sort of let that go. Hands. This is something which we're all guilty of. I'm from New York. I talk with my hands. Don't do the 1, 2, 3. And also on both sides, you're kind of like this. The hand should stay at the podium. You know, if you're in moot court, your hands stay at the podium. Not this, not this, not this. Oh, you can't see where my hands are now, but they're on my desk. For Avik and Zachary, there's a totally zoom point, but if you can elevate your camera so we're not looking up at your noses, right? And this is total. I realize we're in the Zoom generation, but this is just something you have to think about. You don't need to like a ring light, whatever, but just like raise it. And that way we're just not looking at your legs. And this is, we're not going to take any points off, but I'm for your own competition, just because you guys are advancing, I'm pretty confident, right? But just to, it's like the camera should be your eye level, right? Because right now your camera's actually your eye level. Before, and you were standing, you're at this sort of podium thing, we're looking up. And then I think you were holding paper, right? Don't hold paper. Right,
Okay.
just have both of your hands, even if you're sitting at a table. You don't need to have a podium. I know it looks kind of nice, but if you don't have a podium big enough for the two of you, just kind of be standing, no hands visible, and that we're just looking at your they call it kind of a frame. It's basically up from like the couple inches below the tie to the top. So I think Gabriella and Collins are more or less that level, kind of where the jacket. I don't wear my jacket clothes. I should, but where the jacket closes up, right? That's the sort of framing you have to do. Just as a professor on Zoom, there's all, I think about the framing. I'm not doing it now, it's kind of leaning back, but if I was for real, I'd be sitting up straight. But yeah, that was really special. I can tell how much work you put into this, how much thought you put into this. Because I came at you extra hard. I have like different lines of questions, my A questions, my B questions. You got all my A questions. Like I didn't even give you these softballs. Like, what's the level of scrutiny, right? I went very, very hard. So I have no further comments. You guys did a fantastic job. I'm very proud of you. And I can't wait to see what you all accomplish. Now, Gabriella, you guys are now juniors, I guess, or about, yeah, what year?
Yeah, we're juniors.
And what year are you two?
Juniors.
We're both juniors.
All right, so you still have another year of high school ahead of you. I hope as you're looking towards college, you start thinking about law school, because I think it'd be a shame to our profession if we don't have you in it. I mean that sincerely. You're gonna kick butt wherever you wind up. And do great things. We always ask questions for us, either about the round or about the tournament or anything else you want to inquire.
Thank you so much for all the kind compliments. It really is, it's fun when we get to do all our hard work and we get to do these rounds, and man, we appreciate your judging and putting the competition on so much, because we love the competition.
Thank you.
Yes, thank you.
It's a labor of love. We've been here all day since 10 o'clock, so we got one more after you, but we were very passionate. We were all day yesterday also, so this is my one weekend of the year I don't have. The weekend just kind of disappears. Avik and Zachary, any questions for you?
No questions.
No questions.
Yeah, thank you. We
Thank you so
repeat
much for the
sentiment.
feedback. Yeah.
Yeah. Oh no, and of course I don't give compliments easily. So Ashley and Reed will attest. Not all the rounds requires effusive. It's actually bad. Professors shouldn't do this where they're like they give praise to someone, not others. But I've never followed that rule. My students know I'm not happy when I'm happy. Right, guys? Yeah. Okay, they're nodding. All right. That's all I have for you two. You four. We'll post the scores tomorrow. But thank you again, and we're so happy to have you.
Thank you.
Thank you.
Thanks. If
Bye.
the students can just sign off, and I'll talk to the judges for a bit. Stop the recording.